Hi, my name is Xuan. Today, I will explain the legal issue surrounding Alan's purchase of Pinview Cottage and his position as the registered proprietor in light of claim made by Tina and David. The specific legal questions that need to be addressed are: does the Land Registration Act 2002 provide adequate protection for Alan as a registered proprietor of Pinview Cottage, and what types of interests might override his title? Can Tina's alleged lease bind Alan as the new owner of the property, even though there is no record of the lease in the land registry? And will David's options to purchase affect Alan's position as the new owner, even though no record of this option is found in the land registry? To answer this question, it is important to examine the relevant laws governing registered land in the UK, particularly the Land Registration Act 2002, the Law of Property Act 1925, and the legal principle surrounding leases and options to purchase in the context of registered land. Under the Land Registration Act 2002, registration of the title to land is the central to the protection of the registered proprietor's rights. Section 58 of the Act grants a registered proprietor an indefeasible title, meaning that their ownership is generally protected against claim from third parties. However, this protection is not absolute, and there are specific situations where overriding interests may affect a registered owner's title. Overriding interests are certain types of rights or claims that, despite not being registered in the land registry, it may still bind the registered proprietor. Schedule 3 of the LRA 2002 outlines these overriding interests, including interests that arise from leases and actual occupation. In LRA 2002, Schedule 3, Paragraph 1 is an overriding interest which mentions a lease not exceeding 7 years in duration is one type of overriding interest, as long as the tenant is in actual occupation of the property. This means that if Tina's lease with Charles was for a term of 7 years or less and she has been in actual occupation of Pineview Cottage, her lease may bind Alan even though it is not registered in the land registry. Actual occupation is a key concept in determining whether an unregistered interest can override a registered title. If a person has been in an actual occupation of the land, their interest may be protected even if it has not been formally recorded in the land registry. The question in this case is whether Tina's occupation of the property can be considered actual occupation under the LRA 2002, and whether this would allow her to assert a right to remain in the property despite Alan's registration as the new owner. Another important concept under the LRA 2002 is the effect of registration. The Act is designed to provide security of title to registered proprietors and to ensure that any interest in land that are not registered may be extinguished unless they fall within the category of overriding interest. For example, Tina's potential lease could override Alan's title if it was created for a term of 7 years or less, but only if Tina was in actual occupation when Alan took possession of the property. When examining the Law of Property Act 1925, it becomes clear that any lease longer than 3 years must be in writing. If Tina's lease with Charles was for a period exceeding 3 years, it would need to be in writing to be legally effective. Furthermore, leases for more than 7 years must be registered to be enforceable against a new owner under the LRA 2002. Since Tina's lease is not registered in the land registry, this raises the question of whether it is legally enforceable against Alan, who holds a registered title. If Tina's lease is for a period exceeding 7 years, it would not be an overriding interest and would not bind Alan under the LRA 2002. The concept of an option to purchase is governed by the Law of Property Act 1925, which states that a contract for the sale of land, including an option to purchase, must be in writing to be legally enforceable. In this case, David's option to purchase, which was allegedly agreed with Charles, is not registered with the land registry. For an option to purchase to affect Alan's title as the new owner, it must be both written and registered in the land registry. Since David's option to purchase is not recorded, it is unlikely that it will bind Alan unless it meets the criteria for overriding interest such as actual occupation. However, if there is a record of David's option to purchase in the land registry, the situation changes significantly. According to Section 37 of the LRA 2002, For an interest in land to bind a purchaser, it must be registered in the land registry if the interest is capable of overriding the registered title. An option to purchase, which is a form of contractual right giving the holder the choice to purchase the land within a specific period, is one such interest that can be registered. Several landmark cases provide guidance on how the principle of the Land Registration Act 2002 and the Law of Property Act 1925 apply to the issue of registered land and overriding interest. One key case in this area is Kling and Caston 1997, in which the court examined the issue of whether lease, although unregistered, could bind a subsequent purchaser based on actual occupation. The court ruled that if the tenant is in actual occupation of the property and this occupation is known to the purchaser or could reasonably have been discovered, the tenant lease may be an overriding interest under Schedule 3 of the LRA 2002. In Kling and Caston, the court emphasized that actual occupation can create an overriding interest even if the lease is not registered, as long as the occupier present is sufficiently apparent to the new owner. Another important case is Bray and Ford 1920, where the court dealt with an option to purchase that was not registered. In this case, the court held that an unregistered option to purchase would not bind a subsequent purchaser unless it was formally recorded in the land registry. This case underscored the importance of registration for protecting rights such as option to purchase. Since David's option to purchase is not registered, it is highly unlikely that it will affect Alan's title under the Land Registration Act 2002. The case of Williams and Greensbank and Boland 1981 further elaborates on the issue of actual occupation and overriding interest. In Boland, the court ruled that a spouse's actual occupation of the property could create an overriding interest that binds a purchaser even if that spouse's interest was not formally registered. The case highlights the significance of actual occupation in determining whether an unregistered interest can override a registered title. In applying these legal principles to the facts of Alan's situation, we can draw several conclusions regarding Tina's lease, David's option to purchase, and Alan's right as the registered proprietor of Pinview Cottage. First, Alan's title as the registered proprietor of Pinview Cottage is protected under the LRA 2002, and this gives him an indefeasible title to the property. However, certain interests like Tina's lease may override his title if they meet the criteria set out in the Act. If Tina's lease was for a period of 7 years or less, it could be an overriding interest that binds Alan, provided that Tina was in actual occupation of the property at that time Alan took possession. Tina has been living in the property for the past 2 years, and if she has been in actual occupation, she may have a valid claim to remain in the property even though her lease is not registered. This is supported by the case of Kling and Caston, where the court held that actual occupation could make an unregistered lease an overriding interest. However, if Tina's lease were for a period exceeding 7 years, it would not qualify as an overriding interest under Schedule 3 of LRA 2002. In this case, Tina's lease would not bind Alan, and he could not take possession of the property free from her tenancy. Alan should investigate whether Tina's lease is for more than 7 years and determine whether she has been in actual occupation of the property, as this will determine whether her lease can bind him. Regarding David's option to purchase, the situation is more straightforward. Since the option to purchase was not registered in the land registry, it is unlikely to affect Alan's title. The case of Bray and Ford make it clear that an unregistered option to purchase does not bind a subsequent purchaser unless it is formally recorded. Alan's title as the registered proprietor is secure from David's claim, and he does not need to worry about option to purchase unless it is registered or meets other criteria for overriding interest. David's claim will likely be invalid due to the lack of registration, and Alan can proceed with the ownership of Pineview Cottage without concern for these options. A potential counter-argument could arise if Tina asserts that her lease was for a term of existing 7 years but argued that her actual occupation should still bind Alan under the principle of overriding interest. If Tina can show that her occupation was sufficiently apparent, she may claim that her lease, even though unregistered, should bind Alan. However, if the lease exceeds 7 years, it is unlikely to be considered an overriding interest and Alan's title would not be affected by Tina's claim. Similarly, David could argue that his option to purchase should bind Alan because Charles, the previous owner, was aware of it and may have acted in a way that led David to believe it was enforceable. But without registration, this argument would not succeed under the current law and Alan's ownership will remain secure. However, if David's option to purchase is recorded in the land registry, the situation changes for Alan. As a registered proprietor, Alan's title is subject to all registered interests. If the option to purchase is listed as a charge against the title, Alan must honor the terms of the option provided that David exercises it within the period specified in the agreement. This is because under Section 27 of the LRA 2002, any interest that is registered is binding on the registered proprietor and Alan would have constructive notice of the option due to its registration. In this case, David's option to purchase is no longer merely an unregistered contractual right but a recognized interest that is recorded in the official land registry. Alan, as the new owner, is deemed to have notice of the option because it is now a matter of public record. To conclude, Alan's position as the registered proprietor of Pinview Cottage is largely protected under the Land Registration Act 2002. Tina's alleged lease could bind Alan if it was for a period of 7 years or less and if she has been in an actual occupation. However, if Tina's lease exceeds 7 years, it would not bring an overriding interest and Alan would not be bound by it. David's option to purchase does not affect Alan's title and it was not registered in the land registry. Therefore, Alan is likely to be able to assert his right as the new owner, but he should carefully investigate the terms of Tina's lease to determine whether it binds him. That's all for my presentation. Thank you.